Welcome to Beyond the Code, the podcast where industry experts and brilliant legal minds discuss the impact of new emerging technologies. I'm your host, Yitzi Hammer, a lawyer and tech enthusiast. Join us as we explore the legal, regulatory, and ethical issues surrounding AI, blockchain, and more. Get ready to go beyond the code and stay ahead of the game. Three, and we are on air. Go. Welcome back to another episode of Beyond the Code. Today on Beyond the Code, we have Franklin Graves hailing from Memphis, Tennessee. Or is it not Memphis anymore? Nashville, Tennessee, the music center of the world. Today, we're going to talk about some really cool stuff, but let's just start with Franklin introducing yourself.
Hey, yeah, thanks so much for having me. Yeah, I'm super excited. I love your content, the podcast. It's an honor to be joining the ranks of people that you've interviewed in the past. So thank you so much for inviting me and thanks for having me. And thanks to your listeners for putting up with us for the next however long this will be. I'm Franklin. I'm an attorney. Like you said, I'm an attorney in Nashville. Currently, I work in-house. I've always worked in-house, but currently I work in-house with a healthcare company. And I do technology transaction work, and I focus on IP, media, product counseling, pretty much anything that comes through the door tech related. And a key component to that, of course, is emerging technologies. So I focus a lot on doing that type of work in-house for the company. Yeah, so just briefly before that, I was in law school. I graduated in 2014, so I'm about to hit the 10-year mark a little bit. I'm almost there, which feels really weird to even be saying that. But I think under the American Bar Association classifications, I'm no longer a young lawyer, which was a big step, I guess, for me in that sense. I can't claim, I'm so new to this profession. Can you help explain something? But no, yeah. So I've been practicing for a little while, only in-house. Right out of law school, I went and worked for a record label. Did that for about 4.5 years, and then I went and joined Eventbrite, the online ticketing and registration platform. I was part of the commercial team there. Helped go through the IPO process, and was there a little bit after the IPO. And then, right before the pandemic, I guess the perfect time to join a healthcare company. Literally the day before lockdowns hit Nashville was my first day. And I got to see my first time having an office, and I never even got to use it.
And then you said goodbye to it for 2 years.
Yes, exactly. So yeah, that's briefly about me, but I'm passionate also about creators and the creator economy. So I run a newsletter, and I blog and post all the time about creator economy issues. So that, of course, includes the platforms that run and power the creator economy, as well as brands and advertising that powers it from a financial standpoint. And then also, of course, without them, creators on those platforms, there would be no content. So I love also working with creators, especially on a pro bono basis, and getting out there and hearing about their issues and working through it, whether it's IP related or whether it's business related, all of that.
Awesome. And we're on a few Telegram and Twitter groups together, specifically, and I'm going to give them a shout out, the Supreme Court of Web3. I think we both share a passion for blockchain and for, rest in peace NFTs and and just IP developments generally. I very much enjoy your content, and on the topic of your content, you shared an interesting post a few days ago. I'm going to read it. And they just keep coming. More lawsuits filed by local school districts against Meta, including Instagram and Facebook, Snap, ByteDance, and TikTok, and Alphabet, Google/YouTube. These lawsuits are about the mental health impacts of social media on youth. This kind of hit really close to home for me. I don't know if you have kids, but I have 4 of them. My oldest is 12, and we were kind of one of the last parents to cave in and give him a phone last year when he was 11. And, I fight very hard to restrict his access to his phone generally. We limit it to 2 hours a day, or 2 hours of actual screen time a day. And he doesn't currently he's not a member of any social media channels, but he's dying to be. He spends, enough time on YouTube and otherwise. And I see with his friends and his and kids slightly older than him, what a real damage this has on their day to day. I see kids just like walking in the street like with their phones in front of their faces, and it's definitely something that concerns me. It concerns me also with adults. Like I see how much time I myself, but also adults generally spend on their phones and on social media, and there's no question that there are major psychological and mental health related issues that are coming up as a result of this. So I was kind of struck when I saw that post. I saw you wrote also a blog post about it on creator economy law, and started doing like a little bit of a deep dive myself into the various lawsuits that have been filed to date. And I think the really interesting thing here is to what extent are these social media companies at fault? In other words, like by coding these platforms in such a way that they cause them to be addictive, they're intentionally creating mental health issues for youth and adults. I mean, nobody says it that way, but that is kind of the byproduct of what they're doing. Tell me, like, talk this out with me. Like, what are your thoughts? Tell me how do you see these cases going forward? Do you think that they actually have a case here?
So honestly, I think you and I and your listeners too, I believe, are most of them are familiar with the concept of the metaverse and Web3 and what the metaverse for some companies means in terms of an immersive kind of virtual reality, augmented, take your pick there, but kind of immersing yourself and entering into a different universe, a different world. That's one take on the metaverse. And I honestly think, like, to your point of everyone's always on their phone, we're all living in this digital world. I think to a degree we are already experiencing that and having some element of disconnect from the real world around us. And a lot of that is largely due to our smartphones and the communities that we've built and the relationships that we have, or the content that we're addicted to, or the apps we're addicted to on our phones. And I think a lot of the tech companies are recognizing the importance of getting time away from that, or having healthy boundaries around that. That's where we've seen, like with Apple and Google coming out with the screen time type functionality to either help you limit your app usage, or at least once a week remind you of, okay, here's how your app usage has looked over the last week compared to the week before. Here are the apps you're using the most, stuff like that. So from a health standpoint, mental health, societal health, I think that the tech companies are doing something. But then the issue becomes, arguably, is it enough? Because ultimately, when you look at like a meta platforms, but if you look at any of their platforms that they operate, they're all driven, and this is, I mean, I'm attacking Meta right now, but they're the easy target. It's their intention. They make money off of the amount of time that users spend on their app, the amount of time their eyeballs are, and consumers are engaged with the content on their app. And so there's this rub against what is a business best for the business, which is to have users and consumers constantly engaged with the platform and sucked in, versus what is best for individuals and consumers from a health perspective or from a mental health perspective, and also just society at large. And even outside of just the social networking aspect of it, you have like the Netflix model, which was to binge and kind of keep users sucked in. And it's become an attention economy. And so as a result of that, tech companies are engineering in ways, allegedly, as we're seeing in some of the complaints that you mentioned, engineering in a way that keeps users engaged with their platform. So they don't want to leave Instagram Reels and jump over to TikTok, or they don't want to leave TikTok and jump over to Twitter, or they don't want to leave Twitter and jump over to some other app. And that's kind of the
Well,
rub
they
here.
don't want you to leave at
How
all.
do they?
Like they
Or,
don't want
yeah,
you
they
to
don't want to
leave
leave
to
at
go
all.
wash the
So
dishes.
yeah, exactly. Or they want to have, like, I think Professor Scott Galloway is he's the first one I ever heard talk about this. But even our headphones, like the Apple AirPods, are a great example of how they are dipping their toe into a constant in your ear through the transparency mode or otherwise in your ear, being able to listen to audiobooks or podcasts as you're doing the dishes. So even then, if you're not engaged with a screen, mentally you're
Never
still
thought of that.
cycling through something. Yeah. And so it's interesting when you take it and kind of look at break it up. And so I think right now I argue that we are experiencing some version of the metaverse in the sense of we're all so engaged. Like you said, you walk down the street, you see people just engaged on their phone. Now, whether they're using maps to navigate or they're reading the latest news or whatever, or they're either reading on their phone, their screen, or they're listening to their headphones, and we're all disconnected from the world around us, disconnected from society and the relationships that builds. So yeah, I think that just to draw a distinction there, or like the parallels there, I think to what some were saying would be the metaverse of the future. I think that we're gradually getting there, if not already there to a degree. But for the platforms, I think the lawsuits are interesting because again, it's not just Meta, it's Snap, it's Google and YouTube and Alphabet that are named, it's TikTok, ByteDance. All of these are targets of the lawsuits, and it's stemming from back over the last 5 years, maybe even 10 years, really the last 5 years, where we had reports coming out about the harm that social media was having largely on teenage girls. That's where a lot of the earlier reports were coming out about how self-harm, mental health harms, all of that were coming around. And then you had Frances Hagen come out, and the whistleblower from Meta, and sharing the internal documents that allude to the fact that they knew how addictive their platforms were. They had internal researchers aware of it, presenting on it, and nothing was done. Or it was allegedly tried to bury it. So if you look at the complaint, that's where a lot of the news and all the articles that were coming out, the investigative reporting that was being done, and the research that was being done, a lot of times dealing with adolescents, dealing with minors, the harms that it was having on them from a mental health perspective. A lot of research was coming out, a lot of research was done, and that's where a lot of that is now thrown into this lawsuit. And it's interesting because it's pretty much the same firm going after and filing all of these, or the same complaint being recycled over and over again. It's the school districts that are bringing it because they're harmed. So you're trying to tie the harm there. They're harmed because they're having to spend more money on school counseling and mental health initiatives, and it's costing school districts and therefore taxpayers from the harm.
Right. I think the interesting thing is, like, if you actually look at what they're asking in the lawsuit, right? They're not asking them to stop these harmful actions. They're asking for them to allocate funds towards like awareness of digital health, and to like sort of mitigate the damages that have already been caused. But to the extent that they're not going to change the way that they structure these algorithms going forward, then we're just going to have to keep setting up awareness programs and like, I don't know, other kind of like mental health rehab for like dealing with how people are addicted to digital devices. And then even if like people become aware of how they're addicted and they come up with practices how they could deal with their addiction, the platforms allegedly would just go ahead and figure out a new way to make people stay on. So it just seems like really hopeless.
Yeah, well, from a business standpoint, again, going back to like duty as shareholders, you have an obligation to increase the value of your business and your operations, and constantly be chasing that additional value. And there's only so much time that an individual person, our eyeballs, have in a given day, or our ears, like I was saying earlier. There's only so much time in a day, and so you reach this kind of inflection point of, okay, you've got your user base that you can only keep growing so much, and then within that there's some formula, I'm sure, that somebody can come up with if they haven't already. You have your user base, and within that you have only so many hours, or so many usable hours, that they're awake and that they're able to have time away from a job or something like that. And so then you're looking at that from the perspective, okay, this is our core time that we have to monetize the audience, the user base that we have. And so how do we do that and maximize that and not lose them to other platforms? And so that's why, like with YouTube and other apps being on our smart TVs now, it's like YouTube has seen a huge increase in connected television usage, because people don't have to just watch YouTube on their phone. They still do. That's a huge amount of time, but in reality, like, we're seeing this stuff everywhere now, and it's getting harder and harder to get away from it. But yeah, to the point about the harms, a lot of what we're seeing is from a regulatory standpoint. The social media companies are being held accountable and being expected to include protections for minors. Even in California, we are seeing right now California just proposed and has put out this new law that's going to increase the age from of minors under the law from being 13 to the age of 18 in terms of how platforms and tech companies design their apps for those targeted audience ranges. So anyone up to the age of 18 is now within the threshold of being subject to this new California law about age appropriate design. And it's similar to one that was out in the UK as well. Essentially, we're seeing regulators come in and be like, no, you're going to be held accountable for how you're designing and how you're implementing your user experience for these particular age ranges where you have people that are so sensitive and so open to manipulation and get addicted. The interesting thing, the other thing I'd add here is I'm a parent as well. And so for me, it's like I've had to be just cognizant of the fact of like, I'm putting my phone away now. Like, I'm not going to keep it in my pocket even because I get tempted to look at it. I am leaving my phone somewhere else. I'm going to spend time with my children uninterrupted. And because of that, I think it's interesting. I have this perspective, kind of like you were saying, of I see it's not just an issue with children these days, but it's an issue with the newer generation of parents that have also grown up for at least the last 10 years with some form of social media. We ourselves are addicted. I know I get addicted to it, and it's easy to stay in connected and looking at my phone all the time, but it's important to have those boundaries and understand that about yourself. And so that's where I see the other issue is if we now have a generation coming up raising children, and that generation of the child rearing is also addicted, then they're going to raise addicted children that see and model the behavior of their parents. So there's a whole ecosystem here that's developing, and it's going to be problematic. It already is problematic. I think it's pretty easy to see.
So that's one thing that's just like super scary. Us being on our phones all the time, and just how much ear and eye time is controlled by screens and other devices. But then there's the other aspect of it, like all that time that you're spending on a screen or listening, these corporations are collecting data about you. And then they're taking that data and they're doing really cool stuff with it. I mean, it may be great, it may not be great, but it's certainly like very, very cool. I'm a big Black Mirror fan. I don't know if you've seen the latest season, but there's a crazy episode. Have you seen it?
I don't watch it. I read about it, so I'm aware of what goes on in it, what happens. I mentally I went through the Game of Thrones phase, and after that I was like, I can't take this kind of on-screen kind of twisted stuff. But yeah, I'm aware of it.
It's
maybe
funny
I should maybe I should watch it.
You should definitely watch it. I'm a techie on one side, like I love technology. On the other side, I'm a major technophobe. In other words, it's not that I shy away from technology, but I'm scared of what the potential outcomes for like technological advances are. So when I see things like Black Mirror, it scares the shit out of me. Like these are things that I think about all the time. And the crazy thing with Black Mirror is it's always just like one tiny step away from reality. Like it's like it just kind of like this will be a reality in not such a long time. And so there's this first episode called Joan is Awful, about this just like a average woman, goes to work. She's not like the most pleasant person to some of her colleagues, whatever, and in her personal relationships. And then like she comes home at the end of the day and she turns on Netflix, and here there's like a different name, Streamberry or whatever, and she sees this show, Joan is Awful, and it's like about her, and it's like it's not her, it's like Salma Hayek playing her, but it's her entire day, like, and then she goes to her lawyer and she's like, this is ridiculous. And they said, what do you mean? You signed off in the terms and conditions when you downloaded the app on your phone that they could take all this data and they could use it freely, and that it's a real thing, and like we're not so far away from like having these, and then it turned out like it wasn't even Salma Hayek playing it. It was like an AI generated image of Salma Hayek doing all these things, and it's all done like instantaneously because of how fast data is collected and aggregated, and like how fast they're able to like come up with these outputs through AI. And I was thinking to myself, like, this isn't some like fantasy world. Like all of this technology pretty much exists, and who knows, tomorrow I might turn on Netflix and start and see like Yitzy is Awful. So All these things are very, very, very scary. But there's also another question, like besides the scary element of like, the real legal question of what can you use out of all this output that's generated from AI, whether it's for a television show or for a podcast or whatever. Who does the output belong to? Does it belong to the person who put the input in, who owns the data? These are all like really, really interesting questions that there aren't necessarily clear answers on them. But I know that you're very much in the know, so I would love to hear your thoughts on just like AI output generally. Who owns it? How does it work?
Yeah, no, it's a really interesting question. And I think it's important maybe to take a step back and recognize, of course, there's a whole spectrum of what AI means.
Sure.
There's subsets of that. There's subsets of the subsets and subsets of the subsets of the subsets. There's just, it goes on and on because it is technology that has gone through a period of winters and summers and winters again. And we're now in like a very peak time for it. Again, because of just, again, the processing power that's become available, cloud computing, microprocessors, all that kind of stuff it's like this perfect storm of technological advancements. And part of that is being the generative AI movement is what's most prominent right now. And it's taking this concept of, like you were just talking about, the massive amounts of what people typically refer to as data. I prefer to use the term training materials because in the machine learning context, when you get into training the algorithms and the models and the algorithms and how the algorithms interact with the models, it's more than just, I think it's fair to say, more than just data. I think at this point, from a regulatory standpoint, from a societal standpoint, and from an industry standpoint, we have to get more comfortable with acknowledging its training materials and what exactly are those materials. To your point, is it personal information? Is it sensitive information? Is it personal health information? There's whole different levels of varying levels of sensitivity around that. And we have laws in place, largely from the EU, but also we're seeing them in the US, that address those types of issues. But then you get into this question of, okay, well, is it lawfully collected? If it is, then how can it be used? What type of information is it? How is it lawfully collected? Because if it's internet scraping data, web scraping, then the question becomes, well, is it copyrighted content? Is it public domain? Is it under some type of Creative Commons license, which still requires attribution? Is it some type of open source license in the instance of software code? And so those are the types of questions we're seeing play out in courts right now, in lawsuits in the U.S. as well as in the U.K. and other places. I believe, yeah, we've seen it a lot of other places, but for right now, it's this question of, okay, well, what is legal? What are the legal implications? Is that fair use? Is it a different underlying use to copy the training materials and then feed them into a model to compete with like Midjourney or Stability AI? Is there an argument to be made that their use cases are actually competing with the market for the original works they copied? So that if it's a photographer, I can just generate a photo for my blog post that's relevant, and I don't have to go and get a stock license that would have paid a photographer or paid an illustrator or something like that. There's all those different questions. But then when it comes to personal data, there's the whole issue, and we're actually seeing in the EU, going back to Black Mirror, I think one of the first episodes, I didn't see it, but one of the first episodes was social engineering, and in terms of societal scoring and all of that. That's
Yeah.
actually one of the prohibited uses in the EU AI Act. They acknowledge different levels of how AI is implemented, and one of the ones that they absolutely prohibit, just off the board, is this societal engineering and manipulation of how people make their decisions and tweaking that and manipulating them, actually. And so I think whether, like, we've seen what China does or doesn't do, and because I don't have personal experience there, but I read about it. It's this whole question about, okay, well, how is the AI tool being used? And so that's the first question for me, is what's the use case? And then you go into the questions of, okay, well, what's powering the models that are powering the software and the algorithms that are then being used to generate some output. And an output could be, like you were saying, it could be a decision that somebody makes. It could be an automated decision, like this person gets denied for their credit card because of an algorithm, or it could be outputting of content. And so if you output an image, if you output a new blog post and you just post that, there's a whole slew of issues that come around and can be examined from that perspective. But going back to the platforms, it's like if there's an NPC, non-playable character in a video game, or that's part of some metaverse environment, it begs this question of, okay, well, what does it look like for humans to be interacting with a non-human AI bot that looks and feels and sounds real and responds and engages in a very human-like way? What are the implications of that? Maybe I never saw the movie Her, but it brings back memories of that. And then the other issues there, like if it's like a chatbot, like Snap put out a chatbot and had that as part of what users could engage with as like a premium offering, then it was free and back and forth. It begs the question, and we're seeing, of like what happens when users are engaging with these types of tools, these types of new emerging technologies. And getting back to the health implications, it's like, well, if the Snap chatbot is telling someone to commit harm of some kind, or if OpenAI is helping someone learn how to commit suicide, then there's an issue. There's a huge issue there in terms of how these technologies are rolled out, how they're monitored, and how users can engage with them. And so that is a whole nother area that we're already seeing come around, and we're just in the early stages of the generative AI movement. So yeah, that still remains to be seen, and we're already seeing proposed legislation, questions surrounding whether Section 230 applies, which is the immunity for platforms for hosting user-generated content or content at the direction of users. And so whether chatbots, whether a generative AI tools fit within that, remains to be seen. A lot of people are arguing no, some people are arguing yes.
Yeah. In its simplest form, like let's say I want to put up a post on LinkedIn, and I don't want to go and buy a stock image, and I don't want to have to use my own pictures. So I go to Midjourney and I tell Midjourney what I want it to create for me, and then I take the output and I share in my LinkedIn post. Number one, am I infringing on anybody else's IP? Number two, is that image copyrightable, like under my name? Number three, is if it's infringing in any way, does LinkedIn share any type of liability in that? Like, these are questions that I think about that should be easy to answer, but I still haven't been able to get like a clear answer from anybody. So like what do you think?
Yeah. So number one, it's the end user using the tool most likely does not have liability from if there's a claim brought against a illustrator, photographer whose training materials were used to train the algorithm that end user is using. I think it's a lot of people are, well, first of all, I'm not giving legal advice specific to anyone's situation.
Yeah,
we're talking through hypotheticals, all of that. So just for listeners to know,
do your own research,
I know
not legal advice, not financial
yeah,
advice.
Exactly.
That is the precursor to everything on this podcast.
Yes, but no, yeah. So in that situation, then,
wait, so there's like 5 people involved in this chain. There's the person, there's the artist who contributed to the training materials. Okay, there's
willingly or unwillingly. That's
right. Okay, then there's the platform that enabled the creation of an output from the training materials. Then there's the user who input something, a prompt into that platform in order to create the output, and then there's the output itself and wherever it's distributed. So like, let's just walk along that line 1 second. I want to understand like the who's and the what's. So
so the claims for that.
Let's assume that the artist
contributor
who contributed to the training materials owned the art. Okay.
Well, yeah, I mean, it doesn't matter really. Ultimately, I argue why,
if the training materials were infringing to begin with, if I took like all of Coca-Cola's I don't know, logos and popped them in there, then I didn't have the rights to use them to begin with,
in the context of the end user. So if the end user is just using a tool like Midjourney, for example, if they're using Midjourney and they had no direction at all in how Midjourney was trained, the models that power Midjourney were trained, then in that instance, it's going to come down to whether or not the user and their output they generated is substantially similar or infringing. That's going to be the turning point. If they're
Okay, so you're
intentionally
saying if
using
I
or
had
if they're
no
taking an
knowledge,
action.
if I the user who put in the prompt had no knowledge of what the training materials, where they originated, so then it doesn't matter if they were infringing or not infringing. It only matters whether the end result, is substantially similar to is something that I would have knowledge is
Mhm.
a copyrighted.
Because you're looking at like what claims can be brought against that end user, and copyright infringement claims require copying. And so at that
Correct.
point, the end user is using a tool, and the way that the models work, the models themselves don't retain a copy of the training materials. So again, I'm being very general here. There are always going to be nuanced use cases,
Mm-hmm.
nuanced examples, but for the
Sure.
most part, the way that the models work is they don't actually, the fusion models or whatever they are, they don't actually retain a copy of the training materials, that original image that influenced how that output
Interesting.
was
Okay.
generated. So that from that standpoint of the end user just using a tool, you and I going to Midjourney, or you and I even going to Adobe Firefly. Adobe has arguably gotten approvals and has a more license friendly approach to their model development. It's going to still come down to whether the end user is using the tool in a way to just generate something quickly for their blog post, or are they also using it in a way that is,
For commercial
they
use.
know, like they're using an artist's name, they're using a photographer's name, they're using a work that is still copyrightable, and they're trying to they're manipulating at that point, they're intentionally trying to generate a copy of some pre-existing work, then that's gonna flip the switch there, where okay, maybe there is some claim that could be brought against them for liability, because at that point they're dealing with a copy of an original work that is a derivative or some other argument there that they're infringing. And so that's one way that they could have liability. But for the most part, if you're just going and using it to generate an image, essentially to create a copy of an existing work or one that they know is pre-existing, that's the whole issue. But if they're copying the style, they're referencing the style, all of that is not, those aren't copyrightable elements of a work. And so that's where it gets a little thorny. But yeah, so from a user standpoint, your first number one there, that's potentially their liability, but it's relatively, they can use safeguards. And now we're seeing tools like Microsoft's GitHub Copilot that are actually implementing ways to check the output to make sure that it's not infringing, substantially infringing, or whatever on any of the training materials that were used. So that's one way that you're seeing ethical development or
So that's only on the non-infringing side though. Okay, so let's assume it's non-infringing. Is it
yeah,
mine? What could I do with it? Could I use it
yeah.
for commercial use? Could I go ahead and register it or copyright it, or I mean depending what the output is? Could I take it and could I file a trademark? Like what can I do with it, assuming it's not infringing?
Yeah. So no, there's no ownership. Just point blank. The Copyright Office has said that. There is not. There has to be a
Wow.
sufficient. There has to be a sufficient level of human creation in order to meet that copyright threshold. And in their newer guidance, it's this de minimis standard, where it's a modicum of creativity, it's a modicum of human involvement and element there. And so that's really what the turning point is. And so in their new guidance, and I actually wrote an article about this that highlights, kind of gets into the de minimis standard that comes from a Supreme Court case called Feist. And so that's what they're using for their analysis. But generally, no, there's not going to be any ownership. It is essentially a public domain work at that point, because non-human authorship, then it becomes public domain. There's no copyright that can be claimed over that image that is generated, that output that's generated, whether it's an image, whether it's text, whether it's code, whether
So
it's a video, whatever that output is.
that's pretty
And that's
crazy.
actually an argument I made back in 2022. I think I wrote it's 2022 February. I wrote an article examining in the NFT space. Everyone was using and generating like the NFT collections. They were using software. Some of it was maybe AI powered to a degree, if depending on the sophistication level. But also there was this element of compiling. They were taking different assets of a PFP, for example, a character of some kind, and they had different aspects of the character that could be a different color or hairstyles or accessories, stuff like that. And then they would develop and design all of those assets at the front, throw it through a system. It would automatically compile the magic number, usually with 10,000 versions, variations, assign different levels of rarity, all that kind of stuff. And that was one of the first times I started examining this question of human authorship in this creative context. And now it kind of fast forwarded where we're getting this now, we're getting answers finally, but from a generative AI standpoint, where what the Copyright Office is saying, there's just no control when you're using a black box like an algorithm or a model that most of the power most of these generative AI tools. There's no element of human control, and it's just the output is random.
Right, but I thought that there was a distinction between like what we're seeing now in like Midjourney and what you were referring to earlier, like with like the Bored Ape Yacht Club, for example, where you had like certain hand drawn or human created images that were thrown together. You know, like I don't know, 8 apes and like 200,000 accessories that were all human created, and then the algorithm created 10,000 variations of those. So like there was a human element to it. So are you saying now that the Copyright Office has come out and said none of that is copyrightable? Like there's no test of like how I don't know what the de minimis that you're referring to is, but like there's no like how much a human contributed to the input before it was like jungled up and and thrown into an algorithm.
So arguably the analysis that I would perform on that, again, we've not seen it tested in court or registrations denied that I'm aware of for this, but the argument, especially like with the Bored Ape Yacht Club and the like, it's essentially, yes, you could protect those original elements, and those could be registered with the Copyright Office as protectable designs and creative works, potentially. And then the issue becomes, at what point does someone lose control, and at what point does someone, is an artist able to say they controlled the way that those 10,000 variations were output, when in reality there could be millions, multiple millions of different variations. And so that's kind of where I'm drawing this connection, whether it's accurate or not. I'm just pointing out, if you take their reasoning, the Copyright Office's reasoning of the lack of control that an artist has, that's where you're kind of getting into this gray area, especially with NFTs and NFT collections, to be a little more specific there. It's kind of this gray area of like, okay, well, is that sufficiently human authored? The fact that it took these pre-existing assets that were designed and human created, but then they were arranged and selected and all that. Yeah.
So is it? I'm saying you ended by posing a question. What's the answer?
I would argue that it is not sufficient human creation in terms of every individual output. Again, there are going to be distinctions. There are going to be varying levels of use cases there, but that's what I argue in my article. Actually, in that article I wrote, I said, like, to your point, along what line of the spectrum is enough human involvement, and that's where we still don't have a clear answer. It's more of just the Copyright Office is saying, well, if you're like the Feist case was compilations of phone books, and that wasn't sufficiently copyrightable. Well, that's not really helpful here, but it is kind of analogous. If you're compiling a phone book with pre-existing public information, it's kind of a different nuance when you get into NFTs, because you're not compiling public assets, but you're compiling assets in a way that you lose control and you don't have. It's kind of a methodical way of doing it, and not necessarily that's not creative in some instances. So it's a tough question. But I do have a sense of, I would love to see something registered and challenged. And of course, there are a couple Bored Apes that have been registered, and other types of NFTs from NFT collections that have been registered from like a PFP standpoint. But I also argue, okay, well, those registrations were not done by oh my gosh, why am I blanking on their name? I'm terrible right now. The company that owns Bored Ape Yacht Club. Why am I blanking? Yes, Yuga Labs. Thank you. That's embarrassing. But the copyright registration.
You're saying that the individual ape owners copyrighted their apes?
Yeah, so that's the question: is did they have permission to even do that? And so is their registration valid at that point? That's a whole nother question too. Is like, okay, do you have an actual assignment or a license that includes the right to register as a claimant? Because that's in the US, you have to be a claimant on the copyright application, or you have to be the owner. And so if you're a claimant, you need permission to
You're
claim
saying
copyright ownership
to
or
enforce
registration.
potential infringement, you need to be a claimant first. So you need to be registered.
Mm-hmm. Yeah, or like, because I'm the license terms, I haven't looked at them in like a year probably. The license terms for like Bored Ape Yacht Club from Yuga don't include the right to enforce. Because I know, like in the music industry, like in the entertainment industry, a lot of times when you're assigning rights and doing all of that, from like a loan out company to someone, you're also assigning and giving a grant to enforce,
Mm-hmm.
and protect and prevent others, because it's either an exclusive license, or if it's not exclusive, you still include the right or not to enforce. And so if I'm if I'm assigning or licensing, whatever you want to call it, depending on the deal structure, if I'm giving that to a record label in some capacity, that record label is going to ask for the right to enforce and pursue infringers, because they're the ones that have the exclusive distribution rights. And so they're going to want to enforce that against others, and not have to come to you and say, hey, this person's infringing. You gave us the rights. What do we do? Like, we need to do something. So it's kind of this interesting kind of, if you play it out along the line there, kind of what rights are being given to the holder of the NFT, and the underlying assets that accompany that, and does it allow them to register the copyright? Does it allow them to enforce ownership rights they may
Right.
have?
That's the bigger question, because I
Yeah,
mean, you could put anything into a license agreement, and I mean, that's
yeah.
what we've done until now. Like, we've kind of structured it the way that we thought that it should play out. But even if you did give those rights over, the Copyright Office wouldn't necessarily approve them. So, um, I thought there'd be some more clarity around this issue by this point, but it seems that there isn't. And I see that, like, it's slowly creeping into other industries as well. Like, you come from music, like I see that music is probably the next industry to be disrupted by AI. I mean, it's already begun. Definitely, those will be things that will make it difficult to copyright or license the works.
I think it will, like from a stock asset company standpoint, I do see a huge impact to the creative industry, in that sense of, okay, even this podcast, if we wanted to generate some backing track that is not really from a creative standpoint going to, it's not why people are coming to listen to this podcast.
Right.
It's more of just creating a feel, creating an ambiance. And there's that element to, okay, that's where generative AI is really going to fill a void. And kind of like with Microsoft, they're going all in on generative AI powered by OpenAI and powered by their own models as well in the development and they've been doing. And so it's kind of like from a corporate standpoint, if you're using, I can't remember. I think they're moving away from calling it Office 365. I think it's now Microsoft 365. If you're using Word Online, if you're using their tools, or if you're, look, just simplistically, if you're doing a PowerPoint presentation and you are wanting to have a nice little graphical element there, normally you would have to try to find a Creative Commons license or a public domain or Unsplash type license of some kind. But now you can just simply click a button and generate something that kind of goes with the feel and look of the presentation you're going for. And there's an argument there of like, okay, well, what is that going to do to stock licensing, to asset licensing, and where does that fit into the overall conversation, and should it at all? But then on the flip side of that, it's like I kind of take the viewpoint of, well, human creation is going to have it's still going to have its space in the market. I think that, like, from my own standpoint, going back to like what we were talking about, okay, if I'm taking that image and blog post, or that post, and publishing it to LinkedIn, the expectation that I have on that social platform is that I'm there to engage with other humans and other human thought, not necessarily just generative content that somebody's just
Mhm.
thrown up there or the platform themselves have thrown up there. So it's kind of like this social contract. And so that gets back to the point of like, okay, well, from a platform standpoint, it's still all just user generated content. If somebody is coming from like OpenAI or their own tool they developed to generate content and publish it there. But if the platforms were providing that tool themselves, it opens up the whole ball game there, because then they move out from underneath Section 230 liability protections, in my opinion. and they're now facilitating the creation and publishing of the content. Maybe still at the direction of the user, but if the user doesn't modify the output, then that content is not user generated at that point. It's content coming from the platform being published on the platform. So that would be the other distinction, going back to those series of questions you asked, is if the platform is providing the tools to generate the content, that's a whole different analysis than if a user is just coming to the platform to share something and to post something. But yeah, so that's kind of my thoughts on it.
Franklin, this is great. I really, really appreciate you coming on. It's been a fun, interesting conversation. I feel like if we chat again in another month, everything's going to be completely different.
Oh my gosh. Yes.
Which is what makes
honestly.
It fun.
Maybe we can do like a Twitter Spaces if that's still around in a month, and hear from other people to chime in and go for longer.
Definitely. I feel like this generative AI, who owns it? This is a conversation we've been having for over a year, and it doesn't again, I thought like we kind of have like an answer by now, but it doesn't seem like we've gotten anywhere really. And we're back. We were just drilling down into the generative AI copyrightability conversation again, and kind of clarified that just standard prompt into Midjourney or another generative AI tool, that's publicly available, and press send and wait for the outcome. The output, whatever image it is or text that's generated, in and of itself is not copyrightable. So then, Franklin, you were saying when may it be copyrightable?
Yeah, so it's important too to think. I'm looking at this largely from a U.S. perspective. So in the U.S., no, the U.S. Copyright Office has said that generative output, that alone is not sufficient human creativity, human authorship. The issue though is if you're in the UK, they since the 80s they've offered protection for generative works. So it's a different distinction depending on which country you're in potentially. But for the most part, I think if you're going to try to enforce it in the US, the question becomes then, okay, well, how does that work? But yeah, no, in the US under US copyright, the Copyright Office is saying, no, that is not. And we're even seeing that in the denial that Christina Castanova received on the graphic novel they created. They used Midjourney the graphic novel comic. Yeah, they used Midjourney to generate the underlying illustrations, the images, and they went in and did some tweaking to them a little bit in Photoshop, color correction, stuff like that. But then they also added they put the comic book together. They had different panels and panes and did the storyline, complete original story. Yeah. And so when they registered with the Copyright Office was like, "What? Hold up." Well, first of all, they let it go through. But then there was the Ars Technica article that came out. It got a lot of headlines about being one of the first approved copyright registrations for generative AI work. Copyright Office was like, wait, hold up. They pumped the brakes on that. They issued a notice of cancellation, which started this technical process under U.S. copyright law, where they had basically Chris had to come back and explain, and the Copyright Office was examining then how that graphic novel was put together. And ultimately they decided that there's not sufficient human authorship of those generated images, even though there was some additional editing done to them in Photoshop. Ultimately, in their decision, they wrote it, or their opinion on it, their final determination, cancellation, they were explaining that it was too random of an output, and there was no control to sufficiently have human authorship over those images. So they issued a cancellation and then did a new registration that covered only, and I actually wrote about this in one of my articles. I predicted they were going to do this, and they did. They only did they did an application and approved for a compilation. And so the underlying images were excluded assets because they're not copyrightable, they're public domain, but the compilation was protected in terms of the images, in terms of the arrangement of the images, the panel work, and also the text, the story. Those are the two copyrightable, protectable elements in that graphic novel.
That you were saying that there wasn't enough control over the output. So arguably, if I came in, I said that I need to put in 35 different prompts in order to get to the output that I got. Because I'm sure in many cases, I know for me it's like that. Like if I'm trying to get a specific image,
hundreds,
I gotta keep trying until I get exactly what I want. So, and like in the free mid journey, there's the A/B testing. So surely there's a human controllable aspect to that, prompt engineering, just like trying to keep like training the algorithm to get the exact output that I want. That's not completely, random.
I, so from the Copyright Office perspective, they would argue that it is, because you cannot control it. Your prompt is still going through, and you lose control after you write the prompt. And if anything, it's evidence the fact that you have to do so many prompts to get something you're happy with
That
identifies
you
the fact
had
that
no
you have no
control.
control.
Yeah.
And so then the other element there too is like with Chris, they used in their prompt a reference to the actress Zendaya over and over again, because that was the only way to, from a character standpoint, from a
Have a consistent
image
character.
output, to have a consistent look, you have to have a reference of some kind, and that's where a reference model comes in. And so, not getting into name, image, and likeness and issues around like what we were talking about earlier of, okay, well, the prompt engineer at that point is manipulating the tool to infringe arguably in some way, or have a specific output related to what was clearly part of the training material set. All of that, it still begs the question of, okay, well, there's still no control. But it's interesting because Chris is actually challenging it again and submitting, and there are some attorneys at Morrison Forrester, MoFo, that I love that firm name, that are assisting with Chris to pursue a new registration of a new work that involved the control net aspect of the software that allows arguably more control over the output and fine tuning. And it's interesting because Chris started with a hand drawing of what they wanted the output to look like, fed that into the model. But if you look, there's like
Could you do that? You could feed in an image into the,
yeah.
Really?
And so that's the argument they're making, is there that input plus control net additional software that allows in the user to control the tool, kind of like a Photoshop. They're trying to argue that that is sufficient and gets over that hump of what the Copyright Office had previously described as like a lack of control. But if you look and there's some people have talked about it on Twitter and stuff, but if you free, like Chris did a interview, I think it was with Reuters, a little short documentary. You can freeze in one of the B-roll clips of where Chris is working in the control net and the prompt. You can see Chris is still using the name of a celebrity. I think it was Anya. I can't remember the last name, the one that was from that chess game show on Netflix, Anya, whatever. But it is interesting because like that, I think still shows the lack of control over how an image, how a person's face, or how that looks. And so it's going to be interesting to see where all this goes. But yeah, that's an interesting take on it all.
That was really, really interesting. Thank you so much. All right, man. If any of our listeners want to follow your content, I know you mentioned your Creator Economy Law blog. Where else could they find you?
Yeah, I'm online. I'm at Franklin Graves pretty much anywhere online. So LinkedIn, Twitter, Threads, all of that. I am on most social networks. I'm not on TikTok. But yeah, so you can follow me there, but also creatoreconomylaw.com. That's where I publish my newsletter, but also publish on LinkedIn. So feel free to hit me up on all those places.
Thank you for listening to Beyond the Code. If you enjoyed this episode, make sure to subscribe, share with your friends, and to tune in again next week for more fun and insightful conversation.